It's a pleasure to be here. In fact, listening to Wayne's presentation, I think I agreed with most of it. I'll give it maybe a bit of a different slant, but I would say that yes, I think I agree. In fact, I can chop off half of what I was planning to say. My organization, Redress, has been working on the ICC for quite a long time, since before the Rome Statute, principally on the issue of victims. So we engaged with the development of the statute, the rules, etc., and have been monitoring and engaging with the court ever since on issues relating to the mandate of victims. I would say in that particular area, victims' ability to participate in proceedings, victims' ability to claim reparations before the court, there's a lot of symbolic importance about the advancement of the rights of victims before the court, but for the moment, the implementation has been fraught with problems. So in a way, we're waiting for the full realization of victims' rights. We're not there yet. There's a lot of frustration with that. So with that respect, I would agree. In terms of whether the ICC is still in crisis or is it finding its feet, I think that's really, in a way, a self-referential question. How, is this glass half full or half empty? How positive are we going to be? It would have been really nice had the first prosecutor at the ICC been strong, visionary, and had a great team of creative people within the other organs of the court as well to support a different vision of how this court was going to work. That didn't happen. So, like often happens, you have a situation where you learn from the mistakes. How fast are we learning? How fast is the ICC learning? I suppose there's a whole gradation depending on what areas we look at. But certainly a lot of mistakes have been made. Progress is being made, but has justice been delivered, particularly for the victims of these horrible crimes? Not yet. Not yet. And that tends to be the view of most victims that my organization has worked with. They still have a lot of hope for the ICC, but it's a hope of desperation in the sense that they're not getting the justice domestically, at least in some countries, though that's starting to change. So they're looking to the ICC because when the ICC exercises jurisdiction in relation to their case, it means the country in question is not dealing with that case with respect to the criminal prosecution. It's obviously not dealing with the case for victim support or for reparations either. So it's a full package. The fact that the ICC is or has been in crisis, I would say it's not necessarily or only about the people, the officials at the court. It's also about the ICC statute and its limitations. And it's also about the limited degree of state support for the ICC in terms of complementarity. So you have two problems. You have a statute which was negotiated diplomatically, where all the hard questions were simply put to one side. So now the judges are trying to resolve them, and that's a difficult thing. Secondly, you have states who act in their own interest. So when it comes to cooperating with the court in a strong and successful way, you don't have a consistent result. Cooperation has been weak, and the ICC, like all other international tribunals, requires state cooperation in order to carry out basic functions like arrests, etc., evidence gathering, etc. Some broad areas that I want to touch on as examples are, firstly, issues about case selection and whether the emphasis on Africa or is a fundamental flaw of the way in which the prosecution has gone, or is it more symptomatic of other concerns? And in my view, it's symptomatic of a range of different concerns. Of course, the ICC has limited jurisdiction, so that's going to limit the countries that the ICC can look at, the territory of states parties, nationals of states parties operating extraterritorially, referrals from the Security Council, etc. So we know that that's already going to limit and skew the states which are going to be the subject of situations before the court. But also the court has a mandate only over certain crimes, and amongst that mandate, there is a gravity threshold. And here I think it's quite interesting to look at this question of gravity and how the court and the prosecutor in particular has analyzed this, because I think this has, up until now, though, as Wayne mentioned, the strategy paper of the prosecutor indicates a bit of a variance in this respect. But to date, gravity has typically been a question of the scale of the violence or the crime. So how many people have been killed? How many women have been raped? How many people have been tortured? Almost like a scale of the numbers dealing with mass crimes, as opposed to other types of criteria that could also feature in gravity, such as how big was the abuse of power, or other types of questions like the transnational nature of the crimes, which may have a different inflection and be particularly appropriate for an international criminal court to look for. So my view on that focus on numbers means that some of the crimes which one could imagine could go before the ICC are not getting there because they don't fit within that particular characterization. I think it's interesting to look a little bit at the prosecutor's ongoing examination in relation to Iraq, as well as Afghanistan. In relation to Afghanistan, in the ICC prosecutor's most recent report on ongoing examinations, she indicated that not only was she looking at acts which took place specifically in Afghanistan, but she was also looking at the connected potential involvement of Lithuania, Poland, and Romania in extraordinary rendition connected to the treatment of prisoners in Afghanistan, which is quite innovative and important. But then when we look at that in relation to gravity, how is she going to do that, and who is she actually going to prosecute? I think that's where she is now in the investigation, because from a gravity perspective, she'll need to figure out how best to frame that. The second issue about the focus is on the persons who are most responsible, which is a natural phrase thrown out by the prosecution. Well, we're interested in prosecuting those who bear the greatest responsibility, which sounds very appropriate and very reasonable. But when it comes to transnational crimes, so crimes which have a focus between different countries, we can imagine that if the prosecutor wanted to deal with the secret detention which took place in Lithuania. She would have a very hard time to deal with that because who would she prosecute actually? Because the person in Lithuania would not necessarily be the one who was most responsible for the overall plan. So one can imagine this. And this also arises in relation to how she has considered, to date, crimes allegedly perpetrated by ISIS by nationals of states parties of the ICC statute. And this is several years ago, but she made a statement that she wasn't at the time pursuing crimes committed by ISIS members who were nationals of states parties, because those individuals weren't high enough up the chain of command, though of course this could change. So because of her view as to the persons most responsible, you can knock out a whole type of criminal behavior, which can then impact on the skewing of which crimes actually are taken up before the court. I think we're in early days though, but these are areas which merit perhaps further consideration in terms of nuancing the test to make sure that the test of which cases are taken up is not only a test of numbers, but one can look behind that a little bit more. When it comes to cooperation, another really important area, all states parties obviously have an obligation to cooperate with the court, but it's one of those areas which is extremely difficult for a judicial institution which is situated and created within a very political context. It's one of those areas which is set out probably the most vaguely in the statutes. There's a clear duty to cooperate. That's clear in the statutes. But what does it entail exactly? What happens when there's been a failure to cooperate? That isn't clear. Most of the focus to date has been on arrest warrants, and of course we have a very well-known case of Sudan President Bashir traveling all over the place. In a way, he has quite a lot of frequent flyer points, I imagine. But in a way, the constant traveling of al-Bashir to all sorts of countries, in a way it is a slap of the face to the court, in the sense that it's a constant reminder of how weak the court is. And in a political environment, it's very difficult for the court to deal with that. But it harkens back to the early days of the ICTY, before there was some very strong pressure put by the American government to make certain arrests, and some of the other international tribunals, where eventually whatever was blocked was unblocked and it was able to move forward. They had their problems too. But at the ICC, you don't have the biggest players who've been willing to stick their necks out and ensure that arrest warrants take place. Recently, al-Bashir's travel to Jordan is an interesting example. Prince Zayed used to be the head of the Assembly of States Parties from Jordan. Despite all of that very close connection, nothing happens. So I think this is really problematic, both for how it looks, but it also shows that despite the fact that the ICC is a judicial institution, it doesn't want to be seen as doing politics. The lack of very high-level political actors within the court to push these issues is really a big inhibitor, and it's problematic for the ICC. There should be a political animal in the court, wherever in the court, to put the pressure that's necessary to get these issues moving. Unfortunately, does one have the right governments on board at the moment to push this forward? It's difficult to say. Turning to the issue of complementarity, the test of complementarity so far has had very little consideration by the court. Complementarity being, well, the court only has jurisdiction if the national state is unwilling or unable genuinely to proceed with an investigation or prosecution. That issue hasn't come up so much because the prosecutor's team has done its best to get self-referrals from states whenever it seeks to act, which in a way has insulated some of that debate. But it has come up in Libya, for example, which is quite interesting to look at. With respect to Libya, you had an odd situation where Saif Gaddafi, it was determined that it wouldn't be possible for him to be tried in Libya, but al-Sanusi it would. So you have these two contradictory decisions, which arguably they're the same barriers to domestic prosecution would exist in both cases. But then again, from the other side, the prosecution was faced with the knowledge that she'd get next to no cooperation for pursuing the cases. So it's a very difficult debate. With respect to the situation in Libya, when the decisions were taken on cooperation, the situation in Libya was perhaps more promising. It's since gone further downhill. Does cooperation, can that be revisited in principle? Should it be revisited? To what extent does the court take into account human rights in its determination of whether a state is willing or able to genuinely conduct an investigation or prosecution? Human rights are part of the statute to an extent, but only to an extent, and the court does not see itself as a human rights court the way, for instance, the European Court on Human Rights would look at similar types of issues in respect of admissibility, for instance, exhaustion of domestic remedies. So that's a question. But a more interesting question with respect to complementarity is to what extent the prosecution or the, I would say the interest shown by the prosecutor in certain situations, whether they progress to full-blown investigations in cases or not, has helped to galvanize support for domestic investigations and prosecutions. And here I think it's been quite interesting. In the DRC, for example, Democratic Republic of the Congo, there have been numerous prosecutions, some stronger than others perhaps, but the idea that there are prosecutions of war crimes being carried out throughout Eastern DRC is quite important, impressive, and needs to be fostered. And all of that is only happening because of the ICC's engagement in DRC from the very beginning. Similarly, in Uganda, there is a International Crimes Division which is starting to operate now, and in a number of other countries there are similar developments. So there is a growth in domestic consideration of these types of crimes, which the ICC is, by its very existence, fostering, but it could do in a more strategic way, perhaps. There's also, because of the African Union's proposition to the court, a new phenomenon, which is African regional institutions. So you have tomorrow, actually, the Extraordinary African Chambers will deliver its appeals judgment in the case of Hissène Habré in Senegal. And there is debate about, well, it's more than debate. You have a statute which isn't, the court isn't fully implemented, but within the African Union, with a mandate to try international crimes. There's a lot of debate about that because that court would afford immunity to senior officials. But that maybe takes us on a tangent, but just to say that the ICC as an institution has, I think, already shown that it could have a very positive role in relation to fostering domestic processes. And that's something which we certainly want to encourage, and we see it as a positive thing. And we don't see it as detracting from the central role of the ICC, and I don't think the ICC officials see it as detracting either. Faced with a huge mandate, limited capacity, limited budgets, their messaging is very much in line with let's see more prosecutions at the domestic level. When it comes to victims' issues, in general, I would say the rights of victims to participate in legal proceedings and to claim reparations, to be legally represented, to be protected. These are all issues that have been important as a matter of principle, but in practice we have really a mixed bag. I would say my general view with respect to where we are, with respect to the positive implementation of these matters, is that the issue of mass numbers of victims tends to have been used and as an excuse for limiting the approach taken, but also limiting the creativity, and an excuse for very weak results, which has been, in my view, is symptomatic of a number of the wider failings of the court, in the sense that there are certain limitations that the court will have and certain realities that the court faces. The fact that a court which has a mandate to try genocide, war crimes, and crimes against humanity is going to be faced with mass numbers of victims is not a challenge, it's a reality. That is what we're talking about. So when it came to developing the procedures for victim participation and reparations, the court perhaps did not do enough at the beginning to embrace that reality. Instead, it took a very individualistic approach with respect to victim participation and reparations, and as a result, the proceedings have been very slow, cumbersome, and not necessarily helpful or useful or meaningful to the victims that engage with those processes. Looking at victim participation, which is a framework which is probably less common or less will be known about victim participation in a common law room. But essentially, victims can engage in the legal process throughout the proceedings on issues that concern them specifically. So victims have the ability to be legally represented, their lawyers are in court, they have access to certain information, and they can ask questions, etc., make filings in relation to the ongoing proceedings. They're not full parties, but they can apply to participate at different phases if their interests are clearly affected. And there's quite a big jurisprudence at the court on victim participation, which is quite interesting. But because of the huge number of victims, a structure of common legal representation has been put in place, which makes sense, and I don't think there would be any other way to do it, where you have one lawyer or a team of lawyers who represent thousands of victims. In a way, that would have to be the way when you have such, you can't have thousands of lawyers in a courtroom. But the challenge is how the structure of the teams are set up. A team of counsel representing victims, you would imagine, should look very different than a team of counsel representing a defendant. They need to be close to you need investigators, but mainly you need to be close to the accused. And with respect to victims, victims won't be at the court. So the main focus of the team will have to be on the grounds. The problem is that the court has tended to adopt an approach of, let's just put in place what we have for defense counsel and, you know, vary it a little bit if we need to. And starting from that approach has meant that there's been a lot of problems, and the court really hasn't gone so far to develop a structure which is going to meet victims' needs. Also, a general issue is that victims need to apply to participate, so they need to fill out a form to show how their situation puts them in the context of a case, why they are a victim and why they connect to the case. So what is the evidence to show that connection? So if you imagine a case of 3,000 victims, you have a stack of paper like this with those forms, and then each of those forms goes to the defense counsel and to the other parties, etc., who have an ability to vet them. And there's lots of debate, it takes a lot of time, and at the end, what do the victims get? There's a common legal representative who doesn't have a budget to go and visit them and consult them about what they want, representing them in court. So in a way, you have a mismatch in the procedures, which is quite problematic. Another issue with respect to victim participation is how victim participation at the early phases has been very much minimized. If we think about a civil law jurisdiction, so France or Belgium or some other country, the role of victims in the very early stages is quite strong. And there's a lot of interaction with the investigating magistrate on the nature of the charges, etc. But at the ICC, victims are only able to say something, to have a view, when their personal interests are affected. But victims' interests at the early stages are about the scope of the indictment. Well, why isn't there a rape charge? Why are you only looking at this village? The village next door had the same thing happen. Those are the main interests of victims at the earliest phases. But the jurisprudence to date has said that, well, a victim who suffered rape in a case that's about murder is outside of the case, so it doesn't have an interest in the case. So in a way, that's completely limited the ability for victims to participate on the fundamental issue of scope. Then I'll turn quickly to reparations. How long did you say that the Lubanga case had been going on for? Until the prosecution? Until the sentence? 9 years? You can add about 6 to that for reparations. And what year did it start? Sorry. Okay. 2000, let's say 4, 6, 5? I don't know. But the victims in the first case, in the Lubanga case, have not received any reparations. The first reparations decision was issued more than 5 years ago. So the reparation phase, the decision was issued more than 5 years ago. It was eventually appealed, which was appropriate in the context. The time it took from the end of the appeal hearing to get the appeals judgment, I think it was 2 years to get that.